Hi, my name is Diana Chavez. Thank you for joining our webinar. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today, we have a great webinar on licensing considerations and requirements in Arkansas under the No License, No Sue statutes and the filing of a mechanics lien by construction lien law expert Don Overton. Without further ado, I would like to introduce Don Overton.
Hi, my name is Don Overton. I'm an attorney here in Arkansas. The Arkansas Supreme Court does not recognize experts or specialties in anything other than maritime law. So I don't call myself an expert in construction law or a construction attorney because the state Supreme Court does not recognize that specialty. And I have to give that disclaimer at the beginning so I don't get in trouble with the Supreme Court. So under today's seminar or webinar is under the No License, No Sue statutes and the filing mechanics lien. The reason why this is important is that, as we're going to show in here, that even if you jump through all the hoops and do everything that we've done in the previous webinars to file a lien, if you don't have a license, that the specific license is required if you're a contractor, you can jump through all those hoops and it still may not matter. So if you have any questions, you can go to the webinar chat box on the right. We'll do those at the end. Don't put your name or company name in the questions. It's supposed to be somewhat confidential. So what is the contractor under Arkansas law? This comes up a lot because people talk about construction managers, construction advisors, all these other different things. Under the laws of the state of Arkansas, it's all encompassing to where you're either a contractor or not. So we'll just look at the definition real quick. A contractor is any person, and I've underlined the highlighted parts, or the primary parts. So any person, firm, partnership, co-partnership, association, corporation, or other organization that for a fixed price, commission, fee, or wage attempts to or submits a bid to construct or demolish, or contracts or undertakes to construct or demolish, or assumes charge in a supervisory capacity or otherwise, or manages the construction, erection, alteration, demolition, or repair of any building, apartment, condominium, highway, sewer, utility grading, or any other improvement or structure on public or private property for lease, rent, resale, public access, except single-family residence. When the cost of the work to be done, including labor materials, is $50,000 or more. So this comes up where there will be an independent contractor, superintendent, or supervisor that will be hired to oversee a job and they won't be an employee of the contractor or the owner. And they'll say, oh, you can 1099 me and I'll be an independent superintendent or supervisor, whatever. And then they don't get paid and then they want to file a lien and then they're not licensed individually. And then that's where this issue comes up. This issue also comes up with, and I'll just use an example of a flooring company. So a flooring company sells flooring for a commercial job. And then they also have the installer. So they figure they can market that labor double what their installer is charging for that commercial job and add that in with the material. And then the contractor and the flooring person get sideways and then come to find out that flooring company didn't have a contractor's license. And their person they hired didn't have a commercial license. And then that's where this issue comes up as well, because it's not just the labor, it's labor materials. That same situation and issue can arise where the flooring company hires that installer. And let's say the installer's cost is $20,000 for the labor, but the materials are $30,000, $35,000. Well, that laborer will say, well, I'm under the 50 because my labor is only 20. However, under the statute, if that installer's labor is 20, but the material supplier, the material is 35, you've got to put the two together so it gets up over that 55. So I'm not trying to belabor the point, but it's important to understand that labor and materials, virtually anything makes you a contractor. So then let's look at 1725-502. This is a residential contractor. So for residential, we have a home improvement contractor, and we also have a residential building contractor. So a home improvement contractor can basically do anything to a single family residence except start from raw land. They've got to start with some form of structural component. That could be this, they can take a house down to the slab and rebuild it, and that's a home improvement contractor, or any type of remodeling. A residential building contractor can do all the same things, except a residential building contractor can start with raw dirt and build an entire house. So that's an important distinction, because a home improvement contractor cannot build a house from scratch. They must start with at least some structural component, whereas the residential building contractor can build it from raw land. The previous statute said except single family residences. So under the definition of residential contractor, it also says what a single family residence is. So that's any project consisting of at least one, but not more than 4 units of new construction for residential. So if you build 2 duplexes, that's residential because it's not more than 4. If you build 4 spec homes in a neighborhood, that's still residential. If you build the 5th home, then all 5 of them become commercial in that neighborhood. If you do 3 duplexes, that's more than 4. That's commercial. So they would all be commercial. So that's an important distinction when it comes into which license you should have. So what if you don't get the required residential license for contracting to do the work? Under the statute, any contractor who performs work in violation of the subchapters shall not bring an action in law or equity to enforce any provision of a contract entered into in violation of this chapter or for quantum merit, which means if you are a supplier that let's use the flooring example, and I'm not beating up on flooring people, but this is where it comes up more often than not. If you're a flooring company and you have some installers that you work with, and you bill a homeowner for the labor and materials, and you don't have a license, that homeowner could, under 1725-515, if it's in excess of $2,000 for labor and materials, go to court and not pay you, even if you've done the work, because you cannot enforce your contract in law or equity. Quantum merit is Latin. I'm not sure exactly, I can't remember exactly what quantum merit means, but in essence, it means the value of the work. So before they added the quantum merit language in there, you could sue for the value of the work. So that would be the value of the materials minus overhead and profit, or the value of the labor minus overhead and profit. When they added the for quantum merit, that means that you can't even do that. So if you don't have the license, then you cannot enforce any provision of a contract entered in violation. If you can't enforce any provision of a contract, that means that you can't enforce a lien. So if you filed a lien, that lien would be improper because it would be filed by an unlicensed contractor who cannot enforce their contract. And that's what the lien filing is to enforce your contract claims. So then let's look at the commercial license. Again, this is 1725-103. The definition is under 1725-101. So under 1725-103, it says it's a violation of this chapter for any contractor to knowingly do any of the following. And then it basically restates the same definition from 25-101. But then when you get down to D, it says again, no action may be brought either at law or in equity to enforce any provision of any contract entered into in violation of this chapter. No action may be brought at law or in equity for quantum merit by any contractor in violation of this chapter. So that razor-edged sword cuts both in the residential and the commercial. This is a very harsh penalty for the unsuspecting contractor that goes to work for someone, or the unsuspecting supplier that includes labor with their materials in an attempt to try to make a little bit of extra money. So let's look at the application of this, because it is a harsh thing. And when the first time people hear about this, as you can imagine, is when they don't get paid and they hire an attorney that's not very familiar with the construction law, and they file suit, and then they get their suit dismissed by the judge because they didn't have a license. What normally happens in conjunction with that is whoever you have filed a lien against or filed suit against will also file a complaint with the contractor's licensing board against you for working without a license. So on this slide, it says Arkansas Code Annotated 1725-103, which is the commercial statute, is a penal statute is to be strictly construed in favor of the party sought to be penalized. So penal statute means that it's the penalty, and it's supposed to be strictly construed in favor of the party sought to be penalized, which is the party that is being claimed that they do not have a license. And then again, in the Meyer v. CDI Contractors case, which we're going to look at in a moment, the Arkansas Appeals Court said that it must be strictly construed, and if a provision is not clear and positive, every doubt as to its construction must be resolved in favor of the one against whom the enactment is sought to be applied. So now let's look at that Meyer v. CDI Contractors case. So in that case, what happened was that CDI hired Meyer to do some work. CDI and Meyer became adversarial in that relationship, and CDI didn't want to pay Meyer. What had happened was that Meyer, when Meyer applied for their contractor's license, was in the process of doing a job that was in excess of $100,000, again, without a license. Meyer and the person the entity that they were doing the $100,000 worth of work for stayed friends and finished that job, and everything was great. However, CDI, during the course of the lawsuit, during discovery, discovered this. So when they discovered this, they asserted a claim with the contractor's licensing board that Meyer had obtained their contractor's license by fraud, because when you apply for your contractor's license, you have to state if you've done any work that required a license if you've worked without a license in the past when it was required, and Meyer had put that they did not. So during the course of that case, Meyer, when CDI filed their motion for summary judgment on the fraud claim, Meyer did not deny the fact that he was working on a project in excess of, at the time, it says 20,000, and you're thinking, why is it 20 when the rule's 50? In 2008, when this case was decided, the limit was 20. However, it's been raised since then to 50. So, which this case still would apply because that contract, I believe, was in excess of 100. So, Meyer did not deny that they were working on a project in excess of 20,000 at the time they applied for their contractor's license, and he did not deny that he presented false information to the licensing board. So CDI said, well, according to this, it should be clear that there's no genuine issues of fact, and that Meyer's claims should be barred under 1725-103. So Meyer's, to the appeals court, asserted that the lower court made an error because even if he, accidentally misstated on his application and his license wasn't good, that he can still sue for fraud as opposed to breach of contract. And the Arkansas Appeals Court said, well, we don't agree with you, Mr. Meyer, because it doesn't matter how you frame your pleadings. If you do it as a breach of contract claim or as a fraud claim, your claim for fraud is intrinsically founded on and intertwined with the facts surrounding the underlying contract, and the primary relief which you seek, which are your lost profits, is the benefit of the bargain. So they denied his fraudulent inducement claim because under 1725-103. This is an important fact that comes up as well. This goes into the thing under the statute that says that you can't sue for in law or in equity or quantum merit. So the equity is part of this fraudulent concealment, because he's saying, look, that was a mistake. I'm not just suing on the breach of contract. And the appeals court said, the contract is what you're suing on in essence, because if it wasn't for the contract, we wouldn't have this case. So then Meyer made another argument and said that he did not intend to give false information when he applied for his contractor's license. And whether he did was a jury question. He said, you know what, I made a mistake. You're right, I shouldn't have put that. I didn't do 20,000 when I was doing over 20,000. And the Arkansas Appeals Court said, you know, Mr. Meyer, I'm sorry, but we don't agree with you again on that point. Because if you read the plain language of 1725-103, it doesn't require the applicant intended to give false information or to be subject to a term. If you give false information, that's all it is. So if you accidentally do something in terms of applicant applying for your license, then it's the same as if you intended to do it. So then let's look at a more recent case from 2012. This is Central Oklahoma Pipeline versus Hawk Field Services. And this case is important because in this case, Central Oklahoma Pipeline argued that 1725-103 is unconstitutional and that it should be stricken from the records of the Arkansas Code because it is not constitutional. And they said that because it's not constitutional because every person is entitled to a certain remedy in the laws for all injuries or wrongs, and he ought to have justice freely without purchase, completely without denial, promptly without delay, and conformably with the laws. And so Central Oklahoma Pipeline stated that it deprived contractors their right to sue and recover for unpaid work. And in this case, the Arkansas Supreme Court said that the statute's clear and its intended effect to preclude unlicensed contractors from bringing suit. And they commented that unfortunately for the appellants, which is Central Oklahoma Pipeline, the statute is a penal one, and at times harsh results flow from construction of penal statutes. The question here is whether the statute's rationally related to a legitimate government purpose under any factual scenario, and as designed to protect the public, it advances the goal of providing an incentive for contractors to undergo the license process to ensure that the standards set by the licensing board are met. So the Supreme Court upheld this statute as constitutional. The thing to remember on that is that the majority of laws in Arkansas, I have this discussion quite often with clients when they go, that law's stupid. And I always tell them that you know, the primary or the number one industry in Arkansas is agriculture. It's always been that way, and it probably will for quite a long time. So with that in mind, the majority of laws that are enacted by the Arkansas legislature protect children first, then mama, then the family, then the farm, then small business. So if you look at it in that light, this statute protects the public, which protects children and mama and the family from unlicensed contractors that are going to build something that's not safe or that's going to try to take advantage of them. So that's what the statute's for, and that's the more practical application of why it's designed to protect the public. So I know that a lot of people think, well, what does all this have to do with liens? It's really important because if you don't have a valid contract, you can't file a lien. If you're required to be licensed for whatever it is that you've done, even if you have what you feel is a valid contract, under the no license, no sue, even if your contract's valid, even if the work was done, if you don't have the license that was required by the state, then you can't file a lien, because if you do file a lien and the person you filed against gets an attorney that understands what they're doing, then they will have that lien removed and they will go after you for violation of the no license, no sue, and they could come after you for slander of title for filing a lien on a void contract. And so that's all I've got. I know it's a lot and it's a lot to absorb, but it's really important thing that comes up more often than you would think in my practice, where people say, well, I've never had to have a license before. And it's, well, you've never been sued before, or you've always been paid. And so it's real important to understand. And again, like I said, it happens mainly in residential, or in the case of, and I'll use the flooring example, you have a material supplier that will do some labor, whether it's flooring or something like that, and then they won't have a license. So it's just something to be cognizant of and think about. And I'll open if there's any questions, and I'm not sure if there are. Diana will have to tell me.
Dawn, no, I do not see any questions at the moment.
Okay, well, that's it. So our 20 minutes are up. I try to make this short and sweet. I appreciate you coming, and I hope everybody has a great weekend.
Thank you very much, everyone. Have a good one.